Welcome to Impact Makers Radio, featuring industry thought leaders sharing problem-solving insights to help grow your business and live the life you love. And here's your host, Stewart Andrew Alexander.
Hi, and welcome to another Let's Talk Divorce conversation. And on this segment of the show, ladies and gentlemen, I have family law attorney and mediator Paul D. Pearson of Paul D. Pearson Esq, attorney stroke mediator, who is calling in all the way from the Buffalo metro area. Now, Paul has a wealth of experience in the area of family law, and we'll be talking to you today about proven out-of-court divorce resolution processes and techniques. I'm sure he has a lot of great insights to share with us. So if you're a divorcing couple, stop what you're doing and listen in to what Paul has to share with us today. So without any further ado, let's not keep him waiting any longer. Welcome to the show, Paul.
Thank you, Stuart. Glad to be here.
You are so welcome, Paul. I know that you're very busy over there in Buffalo, so I just want to jump straight in, make the best use of our time. So if you could then, Paul, in your own words, just briefly describe the kinds of people you serve and the various types of situations that they find themselves in when they come to you for your help.
My predominant client base is of married couples, who are considering divorce. At least one of them is considering divorce, and the other has been willing to come in and talk about out-of-court possibilities to resolve the issue. What's important both in New York now and in every other state, I believe, is that there is what's called no-fault divorce, which means that if only one party wants to seek a divorce, the divorce can be obtained, even without the consent of the other party. So once people know that, and they understand, even though they're reluctant to deal with the issue or don't want to have to negotiate with their partner, they see the practicality of trying to resolve the divorce issues and the family issues out of court without spending huge amounts of money on lawyers and lots of time in court and waiting around in court. So there's a practical aspect to getting people willing to think about out of court resolutions.
Now that sounds very interesting what you just brought up there, Paul. No fault divorce. Do I have that right? Did you say that? That's what
Yes, you do. Yes, you do. Yes,
can you
do.
just go a little bit deeper into that? Because I personally have never heard of that before. So
Sure.
Please, go ahead.
My understanding, and I haven't researched this myself, but from all the literature that I've read, every state in the United States now has a true no-fault divorce process where a fault ground, a so-called fault ground, such as physical abuse or mental cruelty or an extramarital affair or any other kind of fault ground, does not have to be proved in order to entitle someone to get a divorce. They just have to, in a sense, request it. Now, New York brought in no-fault divorce about 2 years ago and was reportedly the last state to do so. And in New York, the person seeking the divorce only has to assert that the marriage has been irretrievably broken for 6 months. And that's enough of a basis for the court to grant a divorce. So once that's clear to someone, to the other party who may be resistant to divorce or may feel like, well, I'm going to use some leverage to get a better deal and hold up the divorce until then, that can't happen anymore. So it puts people into a position of really having to deal realistically with, okay, there's going to be a divorce. We have certain issues that we know we have to deal with in a divorce context, including division of property, support issues, children's issues, custody issues, all kinds of financial and personal issues, and we need to try to see if we can do that either directly or with the help of a mediator, which I'll explain shortly, or through another out-of-court process called collaborative law. But essentially, it involves the divorcing parties negotiating with each other, with facilitation and supervision by trained professionals.
Excellent. That is a really great insight that you just shared with us there, Paul. So thank you for sharing so generously. Now, keeping in mind that anything that you do share with us today is not legal advice or even legal assistance, can you briefly share one of the most common misconceptions surrounding the topic of out-of-court divorce resolutions and processes and the techniques that are available out there?
Well, the techniques, again, are under the big umbrella of what's called alternative dispute resolution techniques, ADR techniques. And the primary ones that are in use throughout the country are mediation and collaborative law. Now, mediation involves typically a trained mediator with extensive training, actually, and hopefully extensive experience, who helps facilitate effective listening and effective discussion between the parties on the issues that are pertinent to their particular family, but that must be resolved and presented to the court as a settlement agreement in order to have an out-of-court divorce.
Okay, so those are the, or you just described the what a proven out-of-court divorce resolution process can be, or the techniques. But what are some of the misconceptions surrounding out-of-court divorce resolutions? Well,
there are some people who think that if they can get their spouse into a negotiation out of court, even with just a neutral facilitator involved to help, that they will somehow come out with a more favorable result. In my experience, with a trained, experienced mediator involved, that should not be a possible result, because a mediator has an obligation to ensure that there is a fair and reasonable settlement. And the settlement itself often gets written up into what's called a settlement agreement by the mediator, who will then send drafts to the parties, and the parties can review it and consult with whoever they wish. And in fact, they're encouraged at that point to consult with a lawyer. But lawyers do not sit in on the mediation.
In terms of the misconceptions that you just spoke about then, Paul, can you share with us, and obviously keeping client confidentiality in mind, in all of the years that you've been practicing family law, can you share with us at least just one example of how you've helped someone who came to you with those challenges that you just described, with those misconceptions, and what kind of transformational results you were able to gain for them?
Well, very often in a successful mediation, there is a very positive transformation result, as you mentioned, where the parties are actually able to better communicate and better understand each other and have a better empathy for the other party's situation than before, because typically people who come in for mediation have been married 10, 15, 20, 25 years, and a lot of miscommunication has occurred, a lot of misunderstanding and resentments have been built up, and mediation often helps to sort of clear the air on that, and to have each of the parties feeling that they have been heard, and that they have been understood, and that a fair and sensible agreement has been reached. Now, the agreement, when it's written up and signed, becomes the settlement terms for the divorce. So that's the deal, so to speak, even though the divorce itself may not have been begun yet, or the document doesn't get submitted to the court for several weeks or several months. It then, the settlement agreement then becomes incorporated by the court as the terms of the divorce, and is specifically referred to in the court judgment. And so when the settlement agreement is signed, prior to submission to the court, the parties know that that's their deal, and the settlement agreement goes into effect right away, right when they sign it, even though the court has not acted on it yet.
Today's topic is proven out of court divorce resolution processes and techniques, such as the mediation and collaborative, as you just explained. With that in mind then, Paul, and for those divorcing couples wanting to know more, and I'm sure there are many that you've come across in the years of practicing family law, but what's the most common but unknown pitfall that they might not but definitely should be aware of?
Well, certainly in New York State, and I would expect in virtually every other state that has a divorce settlement concept for property and income, that it doesn't make any difference whose name the property is in, and it doesn't make any difference whose name is on the bank accounts, or who earned the money to get the property, or who's earning the income. All of that is part of the marital estate. And in many states, there is a concept of what's called equitable distribution of the marital estate. And for a medium to long length marriage, typically somewhere between 10 years on the low side, but certainly 15 to 20 or 30 years on the high side, the starting point for negotiations and settlement is that there will probably be close to a 50-50 division of the marital estate, regardless of who earned it or whose name it's in. And that includes pensions and investments and bank accounts and real property, pretty much any kind of asset that was acquired during the marriage.
So, in other words, then, if I understand correctly, Paul, the emotional investment that one has in a marriage doesn't really come into play when you go to court. It's all very black and white and very business-like. Am I on the right lines there?
Yes, that is absolutely correct, and that's particularly true if you are actually in court and having a trial in front of a judge, because the judges almost always try to get past any kind of emotional issues and the hurt and the anger and the failed dreams that get caught up in at least one of the divorcing parties, and they deal with it as a very businesslike, as you said, issue. I mean, what's there? Who generated it? How did it come into the marriage? And what's the appropriate division between, or distribution between, the parties? Now, there is one thing that I should try to make clear. Pretty much every state keeps out of the marital estate a concept called separate property. And separate property, particularly in New York, is assets that may exist during the marriage, but that were brought into the marriage by one party and can still be identified, or were received during the marriage by gift or inheritance from outside the marriage. In other words, a gift not from your spouse but from someone else, or settlement monies for a personal injury. Those four categories are not in the marital estate. Other than that, in New York at least, and I think this is probably true in most states, anything that is acquired during the marriage is considered to be part of the marital estate, subject to division.
So it's such a tricky one there, Paul, because I'm thinking about those personal assets brought into a marriage. Two people meet, they fall in love, they date for a few years, they fall in love, they get married, they're married for 10, 15, 20 years, and for whatever reason, they end up in the divorce courts. How does one prove that your personal assets, that they're in the marriage, that you actually brought them into the marriage before the marriage? Is it prudent to make a list, to document that? Even, it sounds crazy. You just got married. Is it prudent to do that? I mean, what do you say?
It would be prudent to do that. And you certainly see that happening in a premarital agreement. Mm-hmm. Which it doesn't happen often, but certainly in first marriages it doesn't. But does from time to time, particularly if either party has substantial wealth or has children by another relationship or something like that. Mm-hmm. It is prudent to identify what you're bringing into the marriage. For instance, sometimes people will bring in a residential home that they've owned prior to marriage and that they had paid for, and or had been gifted to them by some relative. That's very important to try to document. And people generally find themselves in agreement when one spouse says, well, my father gave me such and such an asset, or my uncle willed it to me, or something like that. Typically, there's not a lot of disagreement, and many times there are documents to support that. And if not, there may be the ability to trace things back to the time when the particular asset was received.
Okay, Paul. So you've shared a lot of great information so far in the short amount of time that we have available to us. And I'm sure if there are any divorcing couples who are listening to you right now, they'd certainly want to know a little bit more about you. Who is Paul Pearson? What makes him tick? How did he get started? So in your own words, Paul, could you just briefly tell us a little bit about yourself? And especially in terms of your background, your education, and your experience as it relates to the topic of what we are discussing today of family law.
Certainly. I have always been interested in people issues and family issues. And when I was in college at Bucknell University, I was a double major in psychology and sociology. And then after that, I went to the University of Pennsylvania Law School and took what few courses were available at that point in family law and law and society and law and psychology. And then I spent several years in the service after law school. And when I got out, I started to work in programs that I was the co-founder of that involved issues of law interacting with mental health issues and people problems. And I co-founded and co-taught a program at the Boston Psychoanalytic Institute for 12 years on the impact of law on mental health issues. And I've been involved in many organizations in which I was helping to create a focus on out of court processes through the ADR system or ADR concept that I mentioned earlier. And I did that both in Boston, Massachusetts, through the bar associations there, and a number of other groups that I belong to. And then when I moved to Buffalo about 25 years ago, I also did that through the bar association here as a long-term chair of their ADR committee. And there was one particular piece of understanding that I think would be helpful for your listeners, and that is the collaborative law process that I mentioned earlier, which is an out-of-court negotiation process where each of the parties has a lawyer sitting right next to them all the time. And that's very different from mediation, but the two parties and their lawyers sit across the table from each other and negotiate a divorce and put all the information out with supporting documents, which is also what should happen in mediation. But for a comfort level, for an additional comfort level, each party has a lawyer sitting right with them, and the lawyers are calm advocates for their clients. They're not table pounders and screamers and sharks. Let's put it that way, which you so often might find in court. And what's important to keep in mind is that a successful mediation is at least 50% less expensive than the traditional adversary process of each party hiring a lawyer, and then the lawyers negotiate the terms and get involved in court actions until the case settles. And collaborative law is typically somewhat less expensive than the classic adversary system, but it is more expensive than mediation.
Okay, Paul, it's obvious that you are very experienced in the field of family law. So with that said, I'd just like you to picture the kind of divorcing couples who come to you, who walk through your practice door, and they want to dig a little deeper into their options of out-of-court divorce resolution processes and techniques. With that in mind, and we are coming to the end of the show, so very briefly, what final thoughts would you like to leave with them before we share how people can connect with you, Paul?
Well, I think it's important for parties who are considering divorce to get as much information as possible about what their local alternatives are. In other words, is there a mediation process or mediators, I should say, available in their areas, and if so, are they trained, and can you go online and see their websites and their backgrounds and how they were trained and things like that. Both the mediation and the collaborative law process really do require specialized training for the professionals involved. And again, in mediation, the mediator is a neutral person who may or may not be a lawyer. In my mind, preferably a lawyer, but not necessarily, and who will give some information to the parties about the particular laws and rules that apply in their locale. And it's important that people find ways to identify who's there in their community as professionals, and who are the family lawyers who are members of a collaborative law practice group, is what it's called.
If somebody wants to know more about the proven out-of-court divorce resolution processes and techniques that you have shared with us today, How can they connect with you, Paul? Where would they find you?
They can go to my website, which is on the national major website for mediators, and it's mediate.com/Pearson, Pearson, my last name. And they'll get to the major website, which has a tremendous amount of information about mediation and how it works. And then they'll get to my personal website, which has my background and has my contact information on it. They can also search for me on Google and just put in my name, attorney, Buffalo, New York, and my website, I believe, will come up, or at least my identifying contact information will come up.
For the listeners out there, whether you're driving in your car or maybe you're tuning in at work or listening on your cell phone, tablet, or any other kind of personal device, that's all we have time for today, unfortunately. Once more, that was Paul D. Pearson. Thank you so much for sharing so generously with us today, Paul. You certainly, hands down, have demonstrated that you are a true educator and advocate for your clients' success. So thank you, Paul.
I appreciate the opportunity to have been on your program.
You are so welcome, Paul. And I'd also like to say a big thank you to you, the divorcing couples that are listening in. Thank you for joining us on this very insightful and informative discussion with one of the top family law attorneys and mediators in the Buffalo metro area today. So make sure you do check him out, give him a call, visit his website, mediate.com/Pearson. I'm sure you are going to be in good hands. So again, I'm Stewart Andrew Alexander, and we'll be back shortly with some more leading divorce professionals in this, our series of Let's Talk Divorce Conversations. So, until then, take care, have a great day, and we'll talk real soon.
Thank you for tuning in to Impact Makers Radio. To listen to all past, present and future industry thought leaders and trendsetters, visit us at impactmakersradio.com.